We found it. The $2 million bribe that sent witness 14 to a cell without a trial. J.D. Vance just leaked the offshore wire transfer that proves Judge Caldwell didn't act on preferences. He acted on a payout. And wait until you see whose name is on the other side of this check. It's not just one person. It's the entire list of 12. This isn't speculation anymore. This isn't rumor. This is a paper trail. Bank routing numbers, timestamps, shell company names that trace back to the same cabal that's been manipulating our legal system for years. When a sitting vice president exposes a federal judge taking millions to jail an innocent witness, the walls are finally coming down. Hit that subscribe button right now because this story is about to explode across every platform. You won't want to miss a single update as these names get revealed. Subscribe immediately. This is the kind of coverage they don't want you to see. So what triggered J.D. Vance to go nuclear with this leak? For months, questions have swirled around the detention of witness 14, a key figure whose testimony threatened to unravel one of the most protected networks in Washington. This witness was held without bail, without trial, in conditions that constitutional lawyers have described as pre-conviction punishment. No one could explain why a cooperating witness was being treated like a convicted terrorist. This isn't just another legal dispute. This is about whether our entire judicial system can be purchased, whether a judge can receive an offshore wire transfer and then within 72 hours sign an order that destroys someone's life, someone whose only crime was being willing to tell the truth. When J.D. Vance stood before cameras and held up those documents, he wasn't just making accusations. He was providing receipts. We haven't seen anything like this since the Pentagon Papers. A sitting vice president with access to intelligence channels most Americans don't even know exist, deciding that the public's right to know outweighs the establishment's right to hide. The implications are staggering. If these documents are authentic and multiple forensic analysts are already confirming the metadata, then Judge Harold Caldwell didn't just make a bad ruling, he committed a federal crime. Wire fraud, bribery, conspiracy, and potentially, given what happened to witness 14, something much darker. Here's the full picture of how we got here, who's involved, and why Vance chose this exact moment to blow the whole thing wide open. Because this isn't just about one judge. This is about the 12 names on that list, and some of them will shock you to your core. To understand how we got here, you have to go back to when witness 14 first emerged. This individual, whose identity remains protected for safety reasons, came forward with testimony that connected high-ranking officials to a network that, according to sources familiar with the matter, has been operating in the shadows of Washington for over a decade. Tensions had been escalating for months, fueled by attempts to discredit the witness, unusual procedural moves to seal testimony, and a pattern of judges recusing themselves from the case until Harold Caldwell stepped in. But everything exploded on May 3rd when Judge Caldwell issued an emergency detention order. No hearing, no opportunity for defense counsel to argue, bail conditions, just a signature. And witness 14 was gone. According to court documents that have since been partially unsealed, the stated justification was flight risk and potential witness tampering. Despite the fact that witness 14 had voluntarily surrendered their passport and was wearing an ankle monitor, legal analysts called the reasoning paper thin at best, pretextual at worst. This wasn't about flight risk. This was about silencing. On May 1st, just 48 hours before Caldwell signed that order, a wire transfer of $2,147,000 landed in an account registered to Oceanic Holdings Limited, a shell company incorporated in the Cayman Islands. The beneficial owner of that account, according to documents Vance has now made public, traces back through 3 layers of corporate obscurity to a trust controlled by Judge Harold Caldwell's brother-in-law. The timing is surgical. The amount is specific, and the routing through Singapore, then Cyprus, then the Caymans is exactly the kind of laundering pattern that financial crimes investigators look for. Former Treasury Department analyst Michael Brennan, who spent 18 years tracking illicit money flows, reviewed the documents and stated that this has all the hallmarks of a structured bribe payment designed to avoid Bank Secrecy Act reporting thresholds while maintaining plausible deniability through familial distance. But here's what makes this worse. Caldwell isn't the only one. The same source account that funded his payment made 11 other transfers in the same 30-day period. Different amounts, different shell companies, but the same origin point. That's the list of 12. 12 payments, 12 recipients, 12 people who, according to these documents, were bought and paid for. And J.D. Vance has all their names. Smash that like button if this is connecting the dots for you. If you're starting to see how deep this goes, hit like right now. I read every comment, and your engagement helps this reach more people who need to see it. Here's what the documents actually reveal. The wire transfer originated from an account held at First Maritime Bank of Singapore, listed under the name Global Civic Partners, LLC. This entity has no website, no employees, no physical address, just a registered agent in Delaware and a bank account that has moved over $47 million in the last 18 months. According to corporate records obtained through Panamanian registry leaks, Global Civic Partners is 100% owned by another shell company called Verdant Policy Group, which is domiciled in Cyprus. Verdant, in turn, is owned by a Cayman Islands trust called the Meridian Foundation. Now, the Meridian Foundation, and this is where it gets damning, lists as its primary trustee a man named Charles Weston. Charles Weston is Judge Harold Caldwell's brother-in-law. He married Caldwell's sister in 1998. He has no independent wealth. He has never worked in finance. Yet, he controls a trust that has distributed over $23 million to various accounts in the past 3 years. The $2,147,000 payment to Oceanic Holdings, the account that ultimately flows to Caldwell's family network, was made on May 1st at 3:47 p.m. Singapore time. That's 3:47 a.m. Eastern. 42 hours later, Caldwell signed the detention order for witness 14. But here's the kicker. The transfer memo line wasn't blank. It contained a reference code. WCP 14 contained WCP Witness Containment Protocol. 14, the witness number contained the objective. They literally labeled the bribe with its purpose. Financial forensics expert Dr. Rebecca Okonkwo, who has testified in over 40 federal money laundering cases, told investigators that the use of reference codes in illicit transfers is more common than people realize. But to see one this explicit is extraordinary. It suggests either remarkable arrogance or the belief that these documents would never see daylight. The documents also include a secondary transfer made the same day, $340,000 to an account in Monaco linked to a lobbying firm that has represented interests seeking to discredit witness 14's testimony. This wasn't just about jailing someone. This was a coordinated operation. Additionally, bank records show that Caldwell's brother-in-law, Charles Weston, made a cash withdrawal of $185,000 from a Cayman account just 4 days after the detention order was signed. The withdrawal was made in person in the Caymans during what Weston told family members was a fishing trip. Records from Cayman Customs show Weston entered the islands on May 6th and departed May 8th. No fishing charter was ever booked under his name. And it gets worse. Communications metadata, not the content, but the connection records, show that a phone registered to the Caldwell household made 14 calls to a number associated with Weston's Cayman account manager in the 2 weeks preceding the wire transfer. 14 calls, an average of 1 per day. Former federal prosecutor Nathan Cross emphasized that this level of coordination, this frequency of communication combined with the financial transfers and the subsequent judicial action, if you presented this to a grand jury, you'd have an indictment by lunch. The evidence doesn't suggest improperly. The evidence screams premeditated corruption. And remember, this is just one of the 12 payments. The other 11 transfers, ranging from $890,000 to $4.2 million, went to accounts with similar structures, shell companies, obscure jurisdictions, and beneficial owners who just happen to have connections to individuals in positions of judicial, prosecutorial, or regulatory power. Vance hasn't released all 12 names yet. But sources familiar with the document say that when he does, Washington will never be the same. The bombshell moment came when J.D. Vance stood at that podium, held up the wire transfer confirmation, and said 7 words that will be remembered for decades. They thought they could buy American justice. The room went silent. Reporters who had been typing stopped. Camera operators zoomed in on the document in his hand. You could see the routing numbers, the date stamps, the amount in black and white. His voice was steady, but there was an edge to it. The controlled fury of a man who had seen something that disgusted him to his core. Witness 14 is sitting in a cell right now, Vance continued. No trial, no conviction, just a bought judge's signature. And while that American citizen rots in detention, the people who paid for it are sipping champagne in jurisdictions that don't extradite. A reporter shouted the question about whether this was appropriate for a vice president to release. Vance's response was immediate. What's inappropriate is a federal judge taking $2 million to destroy someone's life. What's inappropriate is pretending we don't see it. That's when it became clear this isn't just another political scandal. This is a direct confrontation between the elected government and the shadow machinery that has operated behind it for years. Vance isn't just exposing corruption. He's declaring war on it. And when a vice president with access to everything decides to burn the playbook and go public, you know the old rules no longer apply. Don't go anywhere. The most explosive part is coming next. Drop a comment right now if you saw this coming. Tell me, did you suspect the judiciary was compromised, or is this blowing your mind? I read every single comment. Let me know. This isn't the first time judicial corruption has threatened the foundations of American democracy. Think back to 2009, the Kids for Cash scandal in Pennsylvania. 2 judges, Mark Chivarella and Michael Conahan, were convicted of accepting $2.6 million in bribes to send thousands of children to for-profit detention centers. Kids who committed minor offenses, showing up late to school, creating a parody MySpace page, were sentenced to months in juvenile facilities. The judges got paid per head. When that scandal broke, Americans were horrified. How could judges, the last line of defense for the powerless, sell out children for money? It seemed like an aberration, a one-time failure of the system. Then came the federal judiciary scandals of the 2010s, exposed financial conflicts of interest, judges ruling on cases involving companies they held stock in, the system promising reform that never materialized. The pattern is undeniable. When corruption takes root in the judiciary, it doesn't just affect individual cases. It rots the entire concept of equal justice under law. But here's the key difference. Now, the Caldwell case isn't about juvenile detention, kickbacks, or stock portfolios. This is about silencing a witness whose testimony threatens powerful people in Washington. This is political. This is coordinated. And based on the 12 payments, this is systematic. The Kids for Cash judges operated on their own, driven by personal greed. What the Vance documents suggest is something far more sinister. An organized network that can purchase judicial outcomes when needed. A catalog of compromised officials, a menu of services. Former federal judge Patricia Martinez, who served 22 years on the bench before retiring, said it plainly. If these documents are authentic, we're not looking at isolated corruption. We're looking at a captured judiciary. And that's an existential threat to the republic. We've seen corrupt judges before. We've never seen anything like this. Legal and financial experts are calling this the most significant exposure of judicial corruption in modern American history. Professor Alan Dershowitz, Harvard Law professor emeritus and constitutional scholar, told reporters that the combination of financial documentation, timing, correlation, and explicit reference codes creates a prosecutable case that any competent U.S. attorney could bring tomorrow morning. The question isn't whether this is criminal. It's why charges haven't already been filed. The legal implications extend far beyond Caldwell himself. Every ruling he's issued in the past 5 years is now potentially tainted. Defense attorneys across the country are already preparing motions to vacate convictions from his courtroom. If the corruption is proven, hundreds of cases could be overturned. Meanwhile, former FBI Financial Crimes Unit Chief Daniel Morrison emphasized the international dimensions. Following money through Singapore to Cyprus to the Caymans requires coordination across multiple jurisdictions. Someone sophisticated set this up. This isn't amateur hour. Whoever designed this payment structure has done it before. Morrison added that the reference code WCP14 represents either catastrophic operational security failure or complete confidence that the system would protect them. Either way, it tells us they've been operating with impunity. Constitutional law professor Jonathan Turley weighed in on the implications for judicial independence. When judges can be purchased, the Constitution becomes a suggestion. Every American's rights are contingent on whether the person deciding their case has been bought, that's not a justice system. That's an auction house. Even conservative legal scholars who typically defend judicial institutions are expressing alarm. George Mason University's Professor William Barker, a longtime advocate for judicial restraint, admitted that if authenticated, these documents represent the most serious breach of judicial ethics I've seen in 40 years of studying the courts. There is no conservative principle that defends bribery. The financial trail itself has drawn attention from international regulators. Sources indicate that the Financial Crimes Enforcement Network, Singapore's Monetary Authority, and Europol have all opened preliminary inquiries based on the leaked documents. Former Treasury official Sarah Chen noted that the amounts involved, the jurisdictions used, and the speed of the transfers all trigger mandatory reporting requirements that appear to have been circumvented. Someone at multiple banks along this chain either looked the other way or actively facilitated the transactions that expands the conspiracy significantly. This isn't just about one judge. It's about an entire infrastructure of corruption and how many institutions were required to keep it hidden. Do me a favor and slam that like button right now. It genuinely helps this reach more Americans who need to see what's happening. If you believe in accountability, if you believe in justice, hit that like button. It matters more than you know. So, what does this actually mean going forward? First, Witness 14's detention is now legally indefensible. Defense attorneys have already filed emergency motions for immediate release, arguing that detention, ordered by a compromised judge, constitutes a due process violation of the most fundamental kind. Legal experts predict the witness will be freed within days, if not hours. The Department of Justice is in an impossible position. Defend the detention and appear complicit, or release the witness and admit the system failed catastrophically. Either way, the credibility of federal detention powers has been shattered. Every defendant currently held pretrial is now asking, was my judge paid too? Second, the 11 other names on that list create a cascade effect that could paralyze portions of the federal judiciary if Vance releases those names, and sources say it's a matter of when, not if. We're looking at potential recusals, emergency judicial reviews, and a legitimacy crisis that could take years to resolve. Case is currently pending before any of these individuals will face immediate motions for reassignment. Defendants convicted by them will demand new trials. The backlog alone could the courts. Former court administrator Patricia Wells estimated that even 5 compromised judges could affect thousands of cases and create delays measured in years. Third, the long-term implications for judicial appointment and oversight are revolutionary. Calls for financial transparency requirements, mandatory disclosure of all family financial relationships, real-time reporting of unusual wealth accumulation are already emerging from both parties. Senator Mike Lee has proposed emergency legislation requiring sitting judges to submit to the same financial scrutiny applied to top intelligence officials. If that passes, it would be the most significant reform to judicial oversight since the 1970s. The implications for public trust in institutions cannot be overstated. A January 2024 Gallup poll already showed that only 41% of Americans had confidence in the judicial system, the lowest number ever recorded. After this revelation, that number will crater further. When citizens don't trust courts, they stop participating in the system. They stop reporting crimes. They stop serving on juries. They take matters into their own hands. The social fabric that depends on a shared belief in fair adjudication begins to tear beyond the courts. This exposure raises questions about what else has been purchased. If judges can be bought, what about regulators, prosecutors, members of Congress? The same payment infrastructure, shell companies, offshore accounts, familial cutouts could theoretically be used to corrupt any branch of government. As former CIA analyst Robert Kellerman put it, this isn't about one judge. This is about whether the American system of government can be bought wholesale. And based on what we're seeing, the price list already exists. The Caldwell case may be the thread that, when pulled, unravels something far larger than anyone is prepared to confront. And then Judge Caldwell made it even worse. Within hours of Vance's press conference, Caldwell issued a statement through his attorney calling the allegations politically motivated fabrications designed to undermine judicial independence. The statement made no reference to the specific documents, the wire transfers, or the shell company connections. Instead of addressing the evidence, Caldwell attacked the messenger. His attorney called Vance's disclosure a dangerous weaponization of executive power against a coordinate branch of government and suggested that the vice president may have violated classified information protocols by releasing financial intelligence. Caldwell himself, through a spokesperson, called the accusations a witch hunt orchestrated by those who fear independent judges willing to make difficult decisions. The problem with that response, he never denied receiving the money. Legal communications expert Dr. Michelle Stanford pointed out that in crisis communications, the first rule is to directly address the central allegation. Caldwell's statement talks about everything except the $2 million. That's not a denial. That's deflection. When your defense is attacking the accuser rather than explaining the bank records, you've already lost the argument. Making matters worse, reports emerge that Caldwell's brother-in-law, Charles Weston, has retained criminal defense counsel and is refusing to speak with investigators. The fishing trip explanation has collapsed. No boat charter, no fishing license, no photos from the trip, just a 2-day Cayman Islands visit that coincidentally aligned with a massive cash withdrawal. Meanwhile, Caldwell has not recused himself from any pending cases. He showed up to court the morning after the accusations broke and proceeded with scheduled hearings as if nothing had happened. Defense attorneys in his courtroom described the atmosphere as surreal. Everyone knows, but we're pretending we don't. Former federal judge Thomas Wheeler called the non-recusal unprecedented arrogance. Any judge facing allegations of this magnitude has an ethical obligation to step aside pending investigation. His refusal to do so suggests either extraordinary confidence and protection from above or a complete break from judicial ethics. Either way, every ruling Caldwell issues from this point forward will be appealed. His courtroom has effectively ceased to function as a legitimate venue for justice. The cover-up, as always, is becoming worse than the crime. But beyond the immediate legal and political fallout, this is really about something much bigger. This is about whether the average American can walk into a courtroom and receive a fair hearing. It's about whether the blindfold on Lady Justice actually means anything or whether it's just there so she can't see the money changing hands. Witness 14 isn't a politician, isn't a celebrity, just someone who saw something wrong and tried to do the right thing. And for that, they were thrown into a cell by a judge who had already cashed the check. If that can happen to Witness 14, it can happen to anyone. Your neighbor, your family member, you. When the judiciary can be purchased, no one is safe. Not conservatives, not liberals, not independents. The Constitution becomes a prop. Rights become privileges that can be revoked with a wire transfer. This isn't a partisan issue. This is an American issue. It's about whether we're citizens with protected rights or subjects whose freedom depends on the financial interests of people we'll never meet. J.D. Vance understood that. That's why he risked everything to show us the truth. Now, the question is, what do we do with it? If this content matters to you, subscribe right now. I'm covering this story every single day as it develops. The other names on that list are coming. The dominoes are falling. Subscribe and hit the notification bell so you don't miss what happens next. Here's where things stand right now. Judge Harold Caldwell remains on the bench despite calls from legal ethics organizations for immediate suspension pending investigation. His caseload has been frozen by an emergency order from the circuit court, but he has not been formally removed. Witness 14 remains in federal detention as of this recording, though emergency release motions are being heard on an expedited basis. Sources close to the defense team expect a ruling within 72 hours. According to reports from multiple outlets, the FBI's Public Corruption Unit has opened a formal investigation into the wire transfers. Subpoenas for bank records have been issued to financial institutions in Singapore, Cyprus, and the Cayman Islands, though compliance from offshore entities is never guaranteed. J.D. Vance has scheduled a second press conference for later this week. Sources indicate he plans to release at least 3 more names from the list of 12, along with additional financial documentation showing the scope of the payment network. Meanwhile, congressional leadership is split. Some are calling for emergency hearings. Others are urging caution, warning that premature action could compromise ongoing investigations. The House Judiciary Committee has scheduled a closed-door briefing for members with relevant security clearances. On social media, #Judge Caldwell and Listoff12 have been trending for 48 consecutive hours. Public pressure for accountability is unprecedented. Keep a close eye on 3 things in the coming days. Witness 14's detention hearing, the FBI's formal confirmation of investigation scope, and most importantly, Vance's next disclosure. Those three other names could include anyone: prosecutors, agency heads, people currently wielding power who don't yet know their names are on that list. The reckoning is just beginning. The stakes have never been higher. The evidence has never been more damning. A sitting vice president has exposed what appears to be a systematic operation to purchase American justice. And we're only seeing the first three names of 12. What happens next will define whether we're still a nation of laws or a marketplace where rights go to the highest bidder. This isn't just another news cycle. This is a constitutional crisis hiding in plain sight for years, finally dragged into the light. Stay vigilant. Stay informed. Share this with everyone who needs to see it. Hit subscribe and the notification bell. When those other names drop, you'll want to be here. I'll see you in the next one.